Okay, I'd like to call the meeting to order. The Wednesday, May 12th, 2021 meeting of the Urbana Human Relations Commission is called to order. Can we have a roll call, please?
Carol Bradford,
She's expected, but I don't think she's here yet. Okay.
Stacy Burnett,
Here.
Reverend Florence Caplow,
Are here.
Megan McKissick,
Here.
Peter Resnick,
Here.
Francis Rigberg,
Here,
Julie Robinson Schaefer is absent.
she's absent today. Thank you. We do have a quorum. And the next, I will accept a motion for approval of our agenda for this evening.
So moved.
Do we have a
Second.
second? Thank you. Is there any discussion of our agenda tonight? Okay, let's have a roll call vote on that approval.
Stacy Burnett,
Here.
Reverend Florence Caplow,
Yes.
Megan McKissick,
Yes.
Peter Resnick,
Yes.
Francis Rigberg,
Yes. We have approval of the agenda. Now we have our minutes from our last meeting, April 14th of 2021. Would someone like to move for their approval?
I'll move.
Okay, a second?
Second.
Thank you. We have, does anyone have any discussion or comments on the minutes? Corrections, additions? Okay, we'll have a roll call vote on that.
Stacy Burnett,
Yes.
Reverend Florence Caplow,
Yes.
Megan McKissick,
Yes.
Peter Resnick,
Yes.
Francis Rigberg.
Yes. Okay, we have our minutes approved. Now we're fortunate this evening to have an invited speaker, Esther Pat, who is an important member of our community. She was formerly an HRC member herself and city council member, I believe, and has long been a champion of tenants' rights in our community as the head of the CU Tenants Union. And she's here tonight to speak to us about fair housing and the issue of conviction record as pertains to discrimination in housing. Esther?
Thank you. And can you see on your screen, can everyone see where it says Urbana City Code Chapter 12? Okay, good. This is my first time doing screen share. I just wanted one correction. I was never actually a member of the Human Relations Commission. I was a member of City Council for 11 years, but I attended lots of Human Relations Commission meetings actually over the years, but especially when the ordinance, right when I started the tenant union in 1976, is when Champaign was discussing their human rights ordinance. And when they were done, then Urbana was looking at adding the housing section that Champaign had to its ordinance. So I was at all those meetings, and I heard all these interesting discussions and learned a lot. I was 20 years old, so I learned a lot. And here we are many years later. I'm going to start with a little bit about just the human rights ordinance and discrimination in general, and then get specific about conviction record. The intent section of the, I can't read it all, of the human rights ordinance says that the purpose is to end discrimination, including but not limited to discrimination by reason of, and it lists 17 specific protected classes and is followed by or any other discrimination based upon categorizing or classifying a person rather than evaluating a person's unique qualifications relevant to an opportunity in housing, employment, etc. And that's really the key elements of this law in terms of understanding anything in it. Is it prohibits discrimination based on categorizing or classifying people rather than evaluating their relevant qualifications. 17 different classes are named just to make clear what the intent was of just by saying categorizing or classifying, but it's anything that has to do with that. The Illinois Human Rights Act allows cities to expand fair housing protections beyond those provided by state law. And there's the citation of it. If anyone says we can't do it, yeah, we can. What additional fair housing protections does Urbana law provide? Well, the classes that are not mentioned in state law that are mentioned in the Urbana law are prior arrest or conviction record, source of income, including Section 8 or other housing vouchers, personal appearance, political affiliation, matriculation, which is student status, age, except the requirement to be a legal adult to sign a contract, and class, which is really best defined as any other discrimination based upon categorizing or classifying someone rather than evaluating their qualifications that are relevant. What are the qualifications that are relevant to renting? A good tenant pays rent on time, complies with all lease terms, does not damage the rental property, and does not disturb the neighbors with noise, criminal activity, or any other nuisance. How do you find out who will pay rent late, violate the lease, or make trouble? And this is really the essence of all discrimination questions. The lawful way is to find out if the applicant has ever before defaulted on rent or created problems when leasing. The unlawful way is to decide that a certain characteristic, such as race or student status or conviction record, is by itself a predictor of bad behavior. A landlord can never use an applicant's criminal conviction record to evaluate his or her qualifications. And I think this is the biggest hang up some people have in understanding this. All protected classes are equal. Under the law, using conviction record as a criterion to evaluate an applicant is no different than using race or religion or ancestry. It's against the law, and it won't really inform you, which tends to be the way prejudice works. Here are some of the frequently asked questions about use of conviction record to evaluate tenants. And when I'm done, I will be happy to answer your questions. A real common one with all discrimination. Does this mean I have to rent to everyone with a criminal record? No, fair housing laws do not require you to accept every applicant. You're required to make your selection in a non-discriminatory manner. And if you look at the exact language of the law in section 1239, and actually throughout chapter 12 of the city code, it's saying any practice which is based wholly or partially, any practice which is discriminatory and is based wholly or partially on race, color, creed, etc., including prior arrest or conviction record, is what is prohibited. And so wholly or partially, no decisions in leasing should be based on a person's conviction record. Where does the law say that I can't ask about conviction record on a rental application? A commissioner asked me, and I gave the answer that's going to be on the next slide, which is sort of the point, but actually there's specific language in the law. Section 1264 lists 9 different unlawful things that are partially or wholly based on discrimination, and 3 of them apply to this question. It's unlawful to include in the terms or conditions of a transaction in real property any actually I can't read all those words, but any clause, condition, or restriction, and the transaction includes the application. Number 5 is a biggie for a lot of things related to discrimination. It's against the law to make, print, or publish, and that includes a website, any notice, statement, or advertisement that indicates or attempts to indicate any preference or limitation. And I love 9, to act or undertake to act in any capacity in a transaction in which a person knows that a violation of this article has occurred or will occur. And again, why would you ask about conviction record? Bottom line is it's unlawful to ask about any protected class unless you have a non-discriminatory reason. And maybe if you think about it that way, that's the best way to understand it. I give 3 examples of named protected classes that you could ask about in certain circumstances. A landlord may ask if a person is at least 18 or an emancipated minor, because someone who's not cannot be held liable for the balance of rent on the lease if they move out before it's up. But other than that, there's no non-discriminatory reason for asking someone's age. A landlord can ask about the source of income in order to verify the fact of the income, because they have to check if they are doing a check on income. But refusing to count certain income because of its source is unlawful, like child support or a housing choice voucher from the Housing Authority, or any of the rent assistance that's now being given out by various agencies in response to COVID. Also, a landlord can ask about marital status because married people are liable for each other's debts if the landlord conducts a credit check or some type of economic background check. Otherwise, if they're not asking about that kind of stuff, they shouldn't be asking your marital status. And landlords should really never be asking about conviction record or race, religion, ancestry, sexuality, any other information that can only be used in a discriminatory way. A lot of confusion about this. Doesn't Ban the Box allow me to check a conviction record before I sign the lease? Ban the Box applies only to employment. It was adopted by the state of Illinois and some other jurisdictions where laws do not prohibit discrimination based on conviction record. So where there's no protection, Ban the Box says an employer cannot ask about the conviction record on the application, but has to wait till the candidate who's going to be offered the job is selected and then check their criminal record. But Ban the Box does not apply to rental or sale of housing here or anywhere else that I've heard of. Conviction record can never be considered in those cases. Landlords often say, but I don't want to rent to someone who's going to commit crimes at my property. I know this is redundant, but again, obtaining references from current and past landlords is a reliable and legal way to find out if an applicant is engaged in criminal activity at the place where they live or used to live. And that's the relevant question, is how do they behave at the place they live? Most convictions for crimes are not for crimes that were committed in the place where the applicant lived. And therefore, a criminal record is not a relevant qualification. And for that matter, as a practical matter, most bad behavior by tenants never results in the police, much less a conviction, which is why conviction record is not a useful tool for actually evaluating an applicant. Here's one that Commissioner Resnick pitched to me, and I think maybe someone asked this at a commission meeting or maybe just asked him. This landlord said that he checks everyone's credit record and everyone's conviction record. And then if he finds a problem, he does a landlord check. I think it's kind of backward, but anyway, that's what he said. And he asked, as long as the conviction record isn't the reason for rejecting an applicant, isn't this practice legal? And the answer is no, because it is unlawful to use conviction record as a reason for anything, including as a reason to check an extra reference or a reason to ask more questions. All applicants should be treated equally, ask the same questions based on criteria relevant to the rental housing. I personally have answered this one several times over the years. Landlord asks, if I rent to someone with a conviction record and he hurts another tenant, won't I be liable? And sometimes people are actually concerned about that. Sometimes they're just picking a fight. No, landlords are never liable to tenants for any loss or injury unless the landlord's negligence was the cause. A person's compliance with the law cannot be considered negligence. And I mentioned that in the last 42 years since the law passed, no landlord has ever been held liable for renting to a person with a conviction record. And I personally am not aware of any landlord who has ever been held liable for anything related to crime at the property. Great disappointment to victims of crime, but landlords are not responsible for crime unless the landlord is the one who committed the crime or was negligent in some way to allow it. Liability for failing to comply with laws is really what gets landlords in trouble, but that is probably a topic for another day. What if the applicant is on the sex offender registry and the property is near a school or park? It's the responsibility of the person with the conviction record to comply with the law that says where he or she can live and play. The law imposes no duty on the landlords or the owners of public accommodations to guarantee compliance by people who might be there. And this is a very, very common question all over the place about discrimination. People often want to know, if I rent rooms in my home, do I have to lease to people with conviction records? If you rent rooms in your home, you can do whatever you want. The Human Rights Ordinance does not apply to any housing where the owner or members of the owner's family would share a kitchen or bathroom with a tenant. In short, if it's really your own home, not just another piece of real estate you own, you can do whatever you want. And finally, why does Urbana include conviction record in its fair housing law? Primarily, it's to be consistent with the fundamental intent of the law, to say you can't discriminate against anyone except one group of people, but it's also to help end race discrimination, to help reduce recidivism and to protect public safety and health. The reason for the law, as stated in section 1261 of chapter 12 of City Code, is that every individual should be afforded the opportunity to participate fully in the economic, cultural, and intellectual life that's available in the city. If a person's already served a judicially imposed sentence for a crime, what would be the non-discriminatory reason to justify denying that person the opportunity to participate fully in life in Urbana? And in terms of, gee, is this fair? Half of all people with conviction records never commit another crime. And that means that half the time a person is presumed to be a future threat, the presumption is wrong. That's how prejudice works. When Urbana's and Champaign's human rights ordinances were first being drafted, a number of African-American people in both cities came to the meetings and stressed the need to include prior arrest or conviction record and to include personal appearance as named classes, because those were the common excuses used by employers and landlords to conceal discrimination based on race. Making the excuse unlawful lifts the veil of race discrimination. And actually, over the years, I've had a few cases of complaints about student status where the real reason was race discrimination. And that's what it's about, is catching them. Also, I think now people know this, use of conviction record has a disparate impact on people of color. The racial disparities in the criminal justice system, and especially the war on drugs, gave a whole lot of people of color, especially African-American people, criminal records. And therefore, use of conviction record to screen tenants has a disparate impact on people of color. Finally, 5 years ago, the U.S. Department of Housing and Urban Development actually issued guidelines warning cities that use of conviction record for screening tenants could violate the federal fair housing law if it has a disparate impact on certain groups. Though I will tell you that I haven't seen anything good come of this other than it was just on paper, and that could be because of the change in administration. But in Urbana, it's against the law. But here's part of the rationale. This is really important, reducing recidivism, what works. And I'll mention when Urbana passed the housing part of the human rights ordinance, our human rights officer was a man named Vernon Brown, who had previously worked as a parole officer. And he really stressed this with the commission, and people, definitely saw the wisdom of it. Half of all people with criminal convictions don't get involved in crime again. And decades of data show that the most common characteristic the non-recidivist share are a job, stable housing, and living with family. And this is really the whole point. Use of criminal conviction records to deny housing or jobs undermines all attempts to reduce recidivism. It separates people from their families, and it puts them in stressful and dangerous situations like living on the street. One last word, and that's about sex offenders. Are we safer when people with conviction records are living under the radar? I know the fantasy is if discrimination were allowed, all of the people with conviction records would disappear, but no, they don't. They're still here. They're just not on record anywhere. Unlawful discrimination does cause people to go underground, and either a lot of people live in places where they're just not on the lease or they're on the street. And specifically, discrimination against people on the sex offender registry has made it far harder for them to be found, which defeats the purpose of the registry. I'm not in favor of the registry, but why it's there is so you can find people. I've been seeing a variety of stories in newspapers about this for the last 15 years. The first one I saw, I quoted here, it was March 31st, 2006, and the front page headline of the Chicago Tribune was, "Sex Offenders Slip Away." And it said, quote, "In a sweep of 81 addresses given by sex offenders in Chicago, investigators found more than 3/4 of them were places where the offenders did not live or were abandoned buildings or empty lots." The Illinois Attorney General identified the problem. Missing people were men who had served their parole behind bars because they could not find a place to live, and they don't release them until they have a place to live. Hence, when they got out, they were no longer on parole, didn't have a parole officer, and were able to disappear into the population. So if people want to raise the safety issue, I mean, the law is the law, it doesn't matter what you think, but in terms of safety, there is a growing consensus that it is much safer for everyone, both people with conviction records and anyone who's worried about them, if they're living in proper, safe housing. Do y'all have questions?
I've got one.
Yeah.
So one thing that caught my eye, and I'd like you to talk a little bit more about it, is this issue of checking the criminal record, but not checking with previous landlords and missing the people who do bad things, but have never been convicted of anything. I thought that was rather interesting.
Yeah, that, and again, that's in terms of the law is the law, but in terms of trying to explain it to landlords and persuade them, I really don't know why anyone would choose to do a conviction record check instead of a landlord check for just that reason. Even criminal activity is not necessarily going to end up showing up on someone's criminal conviction record. And I mean, it might not have even been reported. And if it was reported, it depends on what it was, and the charges can be dropped. I mean, who knows? But if you want to know, I mean, really, the fundamental point is if you want to know how a person is going to behave, find out how they behaved before. And that still isn't, of course, that still isn't an absolute check. One of the things you see in a lot of cases where there is crime in rental communities, or even at a building, the people who commit the crimes have no criminal record, and they may have never misbehaved anyplace else before. So a lot of the focus in terms of protecting people from crime, even with the police, is once someone is being naughty, evict them, which of course doesn't really protect the world from the person, it just protects that location. But yeah, landlords should really think about how conviction records don't tell you anywhere near as much of what you want to know as previous landlord references.
Very good.
Other questions?
Any other questions?
Yeah, I
Emma?
had a question. So actually I have two. One is, it would seem like in most cases, it would be incredibly difficult, given that a landlord can choose who they choose, to prove that these discriminatory practices have happened. I mean, I suppose if it's on their application, that's one thing, but then you can't. Anyway, that seems like other than sort of a kind of written record, it seems like it would be very difficult to prove this. So I'm curious about that.
Oh, that's the exact same problem we have with proving race discrimination.
Yeah.
Because, how do you prove it happened? But I can tell you one thing that makes it a little easier to prove. I'm just thinking of the cases that actually went to hearing or the cases that got settled. One thing that makes renting different from employment, and this is not by law, it's just by social practice. It's common for employers, probably most employers, advertise the job, collect applications, then sort through to see who you want to interview, and then et cetera. Okay, most renting, and I want to emphasize again, this is not the law. A landlord can do it any way they want as long as they treat every applicant equally. So a landlord could advertise a house, collect applications for 2 weeks, and then pick one. That hardly ever happens. Hardly ever. The way the rental market works almost entirely is first come, first serve. And I know I repeat myself again. That's not a law, but if a in fact, we had a case 20 years ago at Urbana Human Relations Commission about just that question. The landlord insisted he didn't discriminate, but he changed his policy. His policy that he put in writing and he said was, the first one who gets me the money gets the place. And when he met the second roommate of 2 people who were going to rent a duplex and saw that man was Black, he changed his policy to, if you get me the money before anyone else calls. But someone else called before they got him the money. This is all within the 24-hour period. And he told them he wouldn't take the money. And so that's a lot of times where you catch people. We've had a few cases. There was one that went to hearing in Urbana and one in Champaign, and this is now 20-some years ago, in subletting, where the original tenant is trying to find a replacement tenant. So it's almost like having a witness on the inside. So the original tenant knows which people were sent to the landlord and how come there was no response back. But I guess the short answer is when they take applications and accept or reject before they take another application, it's easier to catch them. But the real problem with any enforcement of discrimination laws is, especially with regard to housing, there's no law requiring a landlord to tell a tenant why they rejected them. And if the law, if I had one wish that we could get, it would be that the law would require a written rejection and they'd have to give a reason. And then the question is, what non-discriminatory reason did you come up with? But that's not the law. So I just, most people who call tenant union complaining about discrimination won't follow up with the city. And some people out there who are complaining a lot that Urbana doesn't enforce the law won't refer people to the city to file an individual complaint. They want you to do it without the complaints, which I don't know how you do that. I mean, I know somewhat how you do it. You do PR, but as far as catching the individuals, you need the complainant. And I think the reason people don't file complaints is because they think they can't prove it. The burden is not on the, I'm not saying this for the public who might be watching, the burden is not on the victim to prove it. Your job is, just think of it like any crime, any other violation of law. Your job is report it to the appropriate authority, and then you'll get back to them, return their calls when they follow up with you, and let the city try to figure out how to make it work. And I can say on the plus side, no guarantees, and we lose more than we win, but a lot of times people do something wrong because no one calls them on it. I mean, I just see this with, with the things we deal with the tenant union other than discrimination. And when someone calls them on it, then they have to evaluate, do I want to deal with the trouble of this? And they might very well back down. All the cases that human relations officers or human rights officers in the city of Urbana have settled through conciliation have resulted in an employer or landlord thought they could do something. The city contacts them. All right, wait, let me fix it. And they do. And that's the ideal outcome. I wish with housing vouchers, every time a landlord turns someone down because they have a voucher, I wish that person would come to the city and someone at the city would call the landlord and say, hey, did you know this is against the law? And then the landlord would say, oops, and go ahead and rent to them, which sometimes happens. And we need more of that.
And does this also apply to employment?
Does which apply to employment?
The specifically so I'm just thinking, it's probably pretty common that employers in Urbana have a, background check question.
Illegal. It's illegal.
It's illegal.
Except, and this is the big exception for employment. And actually ban the box, bless their hearts, the people who came to you asking you to ban the box. For Urbana to adopt ban the box is a step back in protecting human rights. Ban the box is a reform for places that won't do anything. Since 1979, actually since 75, Urbana's been doing better. But in employment, there are, I forget the number, I think it's 101 different jobs that either where state law either requires that the person not have a conviction record or a certain license is required, and the licensing you can't get that license if you have a conviction record. So if, and this is real important, if an employer is advertising an open position where ultimately the person is going to have to pass a criminal background check because of a state law, then Urbana city ordinance allows it. And I don't have it in front of me, but it's a stated exception. Mm-hmm. But if you're hiring someone to, work in a grocery store and you just feel like, well, I don't want someone with a conviction record, that's against the law. And if the person committed some crime, a judge made the decision about what their sentence should be. And once their sentence has been served, the idea that every employer can go ahead and play judge too is really not in the best interest of equal opportunity employment.
Well, I have a question, Esther, about how do you feel about what's called testing?
Oh, is it needed? Testing is so needed. And actually, when Vasilia Clark was human relations officer back in the 90s, when I was on city council, she was pushing, she wanted testing, and the commission, if you go through all your minutes, you'll probably find 7 different times in the last 15 years that one of the commissioners brought it up and everyone said, let's do it. You might have even voted at some point, but the city's got to do it. And there's money involved, but boy, testing will discover, in fact, yeah, I mean, that's really how you find out what's really going out there. But I'll tell you, prior to doing that, there's one big step that you can do. Big reason I wanted to do this presentation is because this is news to people. I mean, it's been the law for 42 years. And it really, in the last several years, well, actually it goes on and off in waves. If no one talks about it, people forget. And the fact that all those landlords, I saw that list of all those landlords whose websites have right on there, we won't rent you if you've had a criminal conviction in 7 years and things like that. I'm guessing the out-of-town corporations, I'm positive don't know, because I'm not sure anyone at the city does outreach to these out-of-town people when they come and build an apartment building or complex to tell them, hey, we have our own laws. But it really, a lot of people who just, even local companies, I think they just don't know. And y'all need to tell them, please.
How extensive is it for an applicant if they felt they have been discriminated? How extensive is it to file a complaint? I know I'm one that don't like to fill out a lot of paperwork and now kind of just disregard it. So is it a simple process or?
Well, actually, it depends because you're simple. You have to show up in person. And once you tell your story, you're probably gonna have to, someone's gonna have to type it up and have it for you, an official document for you to sign your name and be notarized. So it's 2 trips to the city building. And I don't know, since you folks are the commission, you can tell me what accommodation is made to people. I mean, I assume during COVID there is, but in the past, that's really all the person has to do. And, it really, I'm so surprised when people talk about how hard it is or about how they don't, like, how long is it going to take? How long it takes is what the city's doing. All the complainant has to do is make the complaints, get the information and the facts, and file it, and then see what happens. And I wish more people, it's free. Oh, did I mention that? It's free. So if someone did you wrong, you go down to the city, you fill out a form, see what happens. And if nothing good comes of it, well, it was no skin off your nose. But I do believe, correct me if I'm wrong, Francis, but I believe it's 2 visits to the city, once to tell your story and give them the information, and the other to come back and sign your complaint.
And
Is
it's
that right?
free, yeah.
The only other thing is if the officer has follow-up questions to answer
Yeah.
the phone and answer
Oh.
the follow-up questions.
Yes, I can say from the tenant union perspective, the same thing. Once you file a complaint with another office or agency and they send it to the person you're mad at, they are now engaged with that person and can't get off the hook because they're there for you. So please return their calls or emails. Otherwise, they're just out there hanging and they don't want to sell you out, but it's not a lot. It's not a big effort. You don't have to carry a large rock on your back for 2 months. And I'll also say, particularly, with any of these things, some people say, well, I just don't, this comes up a lot for voucher holders, is they've got 60 days to find a place or they lose the voucher. And they say, well, I haven't got time. I have to keep looking. You can do both. You can keep looking while you go file the complaint and then keep looking. And if the complaint works it out for you before you find something, you get the place where you were turned down. And if it doesn't work out and at least you'll get something else, and then you pursue damages for what they did wrong to you. But you don't have to choose between continuing to look for a place and filing complaints about the one that turned you down.
Good. Anyone else? Well, I want to thank you so much, Esther, for a wonderful presentation. We all learned, and it's very valuable and beautifully presented. So thank you very much.
Well, thank you. And
We'll be in
thank you
touch.
all for your service and your commitment to human rights, because that's what it takes to make it happen. Thank you.
I agree with you 100%. on
Thanks,
everything you
Esther.
said. Okay. That was great. Now we're going to move on to public participation. Let me take a look here. Public participation. We have 2 hands up. Sarah Nixon.
And Sarah, you're muted.
There you go. There you go.
Hello, HRC. This is Sarah Nixon. I have a couple of comments that I would like to offer. So first of all, at a recent Urbana City Council meeting, a member of the public made a comment to the effect that the Cracker Barrel restaurant in Urbana up near the I-74 has a long history of discriminatory practices, and the comment was offered in the context of that restaurant requesting a special kind of liquor license from the city. And so this was a comment offered from someone who felt that the restaurant should be denied that liquor application. I'm mentioning this to you because in response to that public comment, one of the things that Mayor Marlin stated was, in fact, the city has received no complaints of discrimination with regard to that Cracker Barrel restaurant. And then the mayor addressed other issues, and I guess no more was said. That kind of raised a flag for me. And I'm wondering if the HRC should and can and should do a little more outreach, a little more education or educational outreach, because obviously a zero incidence or low incidence of complaints does not equal no discrimination happening. So on the one hand, if there is discrimination going on at that restaurant, and I don't know if there is, the employees there may be completely unaware that this commission exists. And on the other hand, I think the mayor potentially needs a refresher on that basic fact that just because there's no history of receiving complaints does not mean it's not happening. I have another comment with regard to housing, discrimination in housing, or a couple of comments. So quickly, I'm not sure if the sort of anti-discrimination policies apply to cooperative housing. I think I caught most of this presentation, so I understand that a private homeowner is not bound by discrimination rules or laws, but so where would a housing cooperative fall? Would that be within the category of a privately owned private home, or is that in the category of sort of landlords and rental situations? And then finally, with regard to the issue of landlords not even being aware of rules that they're meant to follow, I know that the commission has a budget for marketing and advertising, and I think that you might want to revisit the question of how extensive and effective those campaigns are, because it sounds like, you know, landlords are oblivious, and tenants are also either not necessarily fully informed about rights to file complaints, or and I promise this is my last comment, the issue came up that tenants aren't following through, or they're just, you know, not being good complainants, quote unquote. At least that's how it sounded. And I just want to conclude my comment by raising the issue of retaliation. When you have someone who has been discriminated against by a landlord or potential landlord due to your skin color, for example, you're in a very vulnerable situation. You're looking for somewhere to live. You may not be able to afford taking on a complaint process because you may legitimately fear retaliation. And you may need to maintain a, you know, a kind of harmonious dynamic with potential landlords. So I think it's important to take that into account as well, and not kind of brand people as sort of uncooperative or disappointing complainants. I think if people are not following through, I think they probably have really good reasons for not following through. Thanks for listening to my long comment. Appreciate it.
Fran, you're muted.
Sorry.
I had a question for Sarah Nixon, if she's still available. With regard to the Cracker Barrel thing, and I'll go listen to the city council meeting. I hadn't heard about this. Do you know what the nature of the discrimination claimed was? Was it employment? Was it race? What was the nature, if you know?
Sure. I don't know. And I believe that the person making the comment did not necessarily have a specific incident to point to, but they had concerns about essentially a history and pattern. And I did do some really brief research and learned that Cracker Barrel has in fact been the, you know, named in a class action suit for race discrimination. And they lost that suit. So they were ordered to pay millions of dollars. So that may be part of what that Urbana resident was concerned about.
Thanks,
So,
I appreciate
yeah.
that. And like I said, I'll go back and take a look at the meeting. I'm sure we all will.
You're
but that's
welcome. It
fine.
was 2 weeks ago, so.
Okay, great.
Okay. Yeah, I was going to ask about, was it discrimination against customers or in employment? You don't know. Sarah, you're not sure about that? She's gone. Okay, I also wanted to comment that Sarah asked about co-ops being exempt the way a private home would be in taking a particular tenant. Esther, can you address that? I know in Chicago, there's a bad history of using co-ops as a way of discriminating.
Well, it depends what you mean by a co-op. Because, I mean, that's part of it. A co-op, I live in a co-op. Winfield Village is a co-op. We have individual units and each owner owns shares of the co-op from which they have the rights to their apartment. So basically, it's the same as selling a house. I mean, technically it's a real estate transfer, but it's still a real estate transaction. It's just a transaction of stock rather than of real estate. There are a number of houses in Urbana that are called co-ops, that are co-op in that it's one house where they share kitchen and bath, and the people who live in the house have some kind of group something or other. And I'm not sure if one of them is actually the owner, then it's just like it's your own home. But if Couch, a national organization, contracts with some local group, I forget which one it was, I don't know if this is still going on, but used to be, and then that group is basically the tenant of Couch, and then they are subletting to other people. I actually don't know what the answer is. I think they might be able to avoid it that way because of the sharing kitchen and bath. But that I would suggest, if that actually came up about those places, which again are not a nonprofit of cooperative housing like the place I live or like Winfield Village, but where it's a house where people share bathroom and kitchen, it might be exempt, it might not. I don't know the exact answer. And I suspect that Ms. Nixon, well, I don't know. I think Ms. Nixon might have been asking about that because when people call tenant union about co-op, it's almost always about those houses and not about Winfield Village or a place like where I live. Basically, everybody's a tenant, they're not owners.
The ordinance section, if you want to take a check, is 1264D, and D2 mentions, and I think it is owner or, sharing space with the owner or members of the owner's family. And I think that's the way the exception is written.
Mhm. But the co-ops like Winfield Village, they are subject to the law, correct?
Absolutely, yes. And so is the place where I live. And even places that can, for example, at my place, when somebody puts their market thing on the market, sometimes, I'm sorry to say, sometimes some of my co-owners have said things like, well, I don't want someone with children or no undergraduate students. And I always tell them, we can't do that. If you want to discriminate, you have to ask among people you know and find someone. But as soon as you offer something to the public, if you say this is open to the public, then you have to treat everyone equally. And that's even if it's just a website, and even if it's just you handwrite on a little index card and hang it in a laundromat with a push pin, that is an advertisement and you are bound to comply with law. And if you don't want to comply with the law, don't tell anyone except the people you know about the place.
Okay, thank you, Esther. Okay, Christopher Hansen.
Hi, Francis, can you hear me okay?
Mhm.
Great. So my name is Christopher Hansen. I live in Urbana. I think it's a little bit curious to see the problem still, I guess, described in terms of education instead of enforcement. I mean, the HRC has had the report that Danielle Chenoweth authored what, for 2+ years now, and I'm not aware of about housing discrimination, and I'm not aware of anything that's been done. Maybe it's been a year. I thought it was 2 years, but and you've had a number. I mean, especially when it comes to conviction record complaints. I mean, you've had a number of complaints, not just about private individuals, but even about the city discriminating. In fact, I think you have 7 or 8 of them starting from 8 months ago about the city discriminating in terms of conviction or arrest record. And you've yet to you've got to follow your ordinance or really act on those complaints. And I've also looked at the last few years of human rights complaints in general that were submitted to the city of Urbana. And my review of the last few years indicates to me that even when someone does properly submit a complaint, it's virtually never goes through the correct process. And maybe it has to do with, difficulty following up or any number of reasons that have been mentioned. But my worry is based on my more recent observation that the complaints are snubbed at the city level. And that's what I've been observing and describing repeatedly to this board. So, as far as this, and keep in mind, the HRC doesn't actually need a complaint or a complainant to act. That's written clearly in your ordinance, and I brought it to your attention many times. So as far as this notion that it's easy to submit a complaint, it's only 2 trips to the city building or whatever was said. Yeah, I guess so, but and I don't think the complaint needs to be notarized. Actually, as long as you attest to it, you're fine. But the issue of retaliation was brought up by the previous commenter, and I think that's the biggest concern, is when you submit a complaint, what bad things are going to happen to you. And that may come from, as mentioned, your employer or your landlord or whatever the situation might be. But the biggest problem I've seen is when retaliation comes from the city and city staff and elected officials and friends of city staff. And that's been the nastiest type of retaliation. You have Esther Pat sitting here, and she's engaged in some of the worst of that. She's attacked me endlessly for submitting complaints to your commission and to the CPRB. And that's, of course, an ordinance violation, and it's written right there, and that should be investigated. In fact, it actually says right in the ordinance that if someone retaliates, the HR should investigate it, and that never happens. So that's the biggest concern I see, is actually intentional mishandling and misconduct by the city when it comes to complaints from people who don't want to hear it or don't want to act on it. And like I said, you have so many instances that have been put in your hands over the last year that no one's followed up. No one's followed the ordinance. No one's gone through the process of doing anything about it. And I know Fran and Pete did show up to that city council meeting, and he talked about the conviction record stuff, and that was great. But what about the complaints that were submitted? What's the resolution to that? I think that it's not clear to me. It's not clear to the public. Is the city going to do the right thing? Does this ever have a resolve? And remember, there are time restrictions put upon the city to respond to those complaints, and those are long overdue. So I think it's less an issue maybe of education and more an issue of actual enforcement and following the ordinance and actually being welcoming of complaints and not kind of attacking the people who submit them. Thank you.
You're muted again, Fran.
Oh, Pete. Pete wants to speak. Are you there?
And
Okay.
Pete, now you're muted if you want to unmute.
Thank you, Jason. So I mentioned before the meeting to Fran that I had gotten some personal correspondence from someone who was unable to attend tonight to give public input. And so I was going to read at least as much as reasonable into the record. It's a long message. I've forwarded this to Tamara to distribute it to the commission, and it will be attached to the minutes one way or the other. So Jason, if you would put up the timer so I can keep an eye on how long this is taking me, and I'll stop before the 4 minutes is up. So this message was from Claudia Lenhoff, who is the executive director of Champaign County Healthcare Consumers. And I think I've mentioned her before with regard to this issue, but she sent me a message, and it says, at least in part, I wanted to reach out to you in advance of tonight's Human Relations Commission meeting. I wish I could attend, but I have a conflict with the Mental Health Board meeting. where I have to do a brief presentation. The reason I'm reaching out to you is because I wanted to follow up on some of the conversation we had during our visit regarding CCHCC's efforts to help house medically fragile homeless individuals. As I mentioned at the time, CCHCC was fortunate to get approved for a grant from the City of Urbana through the CARES Act funds the city received. As a result of that funding, I've been able to help multiple folks with motel stays, and I'm working with them to get permanent housing through the RPC voucher programs. Almost all of the folks I'm working with have criminal backgrounds and or are going through reentry in our community. They are no threat to anyone, and they are very medically fragile, which is why they cannot stay at CU at Home, which is now pausing its services for about 5 to 6 weeks. I'm deeply frustrated and infuriated with what I'm experiencing in trying to get these folks housed. All of my clients have been approved for housing vouchers through RPC, but here is the thing. CCHCC has stepped in to fill a need, and I've been working very hard to get these folks housed, but I keep coming up against the same one barrier: unlawful discrimination against people because they have criminal records and or housing vouchers. We at Champaign County Healthcare Consumers, along with the tenant union and Cunningham Township Supervisor's Office, seem to be alone in the wilderness claiming the law prohibits this discrimination, but no one takes us seriously because we're the only ones saying it. This has got to stop. This rampant discrimination is thwarting multiple organizations' efforts to help folks get housed. We are literally paying the price for discrimination from landlords in Urbana against our clients, illegal discrimination. And it is to the point where this has become a crisis. I understand that the city doesn't even have a human rights officer right now, but still I believe the Human Relations Commission can and must take action because this is a real crisis. Here is the action I would like to see the Human Relations Commission take. The Urbana Human Relations Commission needs to vote to tell the mayor that in this crisis, she should immediately send a public statement about these two specific provisions of Urbana City Code: prohibition on discrimination based on prior arrest or conviction record and source of income. And she should send that statement to 1, every agency that administers rent assistance; 2, every government official; 3, the press; and 4, every landlord in the city's database for the rental registration program. I am asking for the following. 1, can you ask the Human Relations Commission to ask the mayor to send such a statement now during this crisis and not waste another month or more to carefully craft the simple statement that during this crisis, we want to remind everyone that in the city of Urbana, it is unlawful to refuse to rent to an applicant because that person has a criminal record or because the household uses a housing voucher to subsidize rent. 2, the point must be to highlight that these two protected classes, because this discrimination on the basis of these two protected classes is what is creating the housing crisis in our community. I would urge that the message be simply based on the two protected classes and not all 17 named classes, because otherwise the message will get buried. Here's the simple message I would like to see put out in this crisis: discrimination against people who have criminal records or use housing vouchers to pay rent is against the law in the city of Urbana. She goes on to mention other things and important information. So like I said, I'll have this attached to the minutes and it will be sent to the commissioners. And I greatly thank Claudia for forwarding this message. It's incredibly important, and I hope the commission can at least give a sense this month to the mayor that we are planning on voting to say to the mayor that you should do this. So thanks.
Definitely. That particular topic isn't on our agenda. We can't take any action on it, but
Right. That's why I said I'm inclined to, at least when we get to new business, just get a sense of the commission if this is okay for next month to vote on it, but maybe be able to say the sense of the commission, Madam Mayor, is that you should probably do this and we're going to vote on it next month.
yeah, I'd be happy to write that. Okay. Thank you, Pete. Okay. Let me just check here. Okay. I don't see any other public participation. So we move on to unfinished business, which we have none this evening. And new business. Did you say you wanted this under new business, Pete?
If we could just, I actually
That
just
is-
want to do a little straw poll and see if, you know, the other commissioners are inclined to ask the mayor to do this sort of thing, and I can prepare a motion for the next meeting and put it on the agenda.
Super. Yes, Florence.
I have some concern just having heard her letter, that this is extremely time sensitive.
That,
So it seems like that perhaps we could have a discussion and one of you could forward this letter with our, like, please do this. I know
Yeah.
you kind of mentioned that, but it does seem like, to put it, you know, into next time is,
and my only comment there was simply that we can't officially vote on it this month because
Right.
it's not already on the
Right.
agenda.
right.
But yeah, I think getting the sense of the commission that we really think this is a good idea, and if you don't do it, we're going to vote on it next month, is probably a good message to send if we all agree to that.
Okay.
I agree to
How do we
that.
all feel? Any objections?
Now, this is Carol. I had the same reaction that Reverend, well, I was going to say Reverend Florence, but
That's fine. That's what I go by.
hopefully you're okay with that. I had the same reaction. I'm not comfortable with putting it off another month. I think she needs to get this, the message anyway, if not the actual letter, ASAP.
Good.
Because I agree with everything that's been talked about as far as, because I work with folks who are struggling with finding a place to live. And I wanted to just throw out there really quick, one way that people are getting around being able to be accused of racial discrimination is they use people's credit histories. And obviously when you come from a background where you may not have had a stable childhood or young adulthood, you may not have had steady employment, you probably don't have the best credit history. And so they know some of them know they can't discriminate based on the protected classes. So they use your credit record as an excuse. So I think part of the work is working with people to help them take care of their credit reports and stuff so that can't be used as an excuse, a way to get around race and criminal record and that type of thing. I guess I have a question. Does anyone know that if the mayor has planned to address this already or has something in action or
Not that I'm aware of.
in the works? Okay.
The only thing we have in the works, at least from our end, is, it's just been a crazy few weeks since the last meeting. I was supposed to get together with city staff and try and prepare the letter to the landlords that are overtly putting it on their website right now or in their applications, and that still needs to be taken care of. We just need to get the list together and get that mail sent out. But this to me sounds like an easy, you know, so long as no one has any objections, I'll forward this to the mayor and say, we have a sense of the commission that we want this done. And
Yeah,
you
it's
don't-
urgent. It's urgent. You know, I know people who were relying on the Phoenix CU home, and people just they don't have anywhere to go, and they have vouchers or they have a source of income, but they're not getting rented to. And so it's bad. And we're seeing more and more people pop up on our streets that are homeless, holding up signs.
Yeah, I think a combination of Esther's presentation and the letter that Pete read would, I mean, those two things together really tell us what we need to do. So we'll do it.
Okay,
And
so I'll
we-
take that action item to forward what's needed to the mayor and, keep an eye on finding out what's done. And if it doesn't happen before the next meeting, I'll prepare a resolution to put on the agenda for the next meeting.
We can always have a quick meeting if we need to as well.
True enough.
No
Yeah,
problem.
there's that's a good point. Yeah.
Mhm.
By the way, have we heard anything about an officer?
Well, I was going to ask Elizabeth about that. We did have interviews.
So,
But yes, go ahead, Elizabeth.
yeah, I was gonna do this later, but
Okay.
the mayor is going to make an appointment, and that will be up for council approval on May 24th. So I can't give you the specific name of the person because that hasn't been made public yet.
Sure.
But that appointment would be in the packet the week prior. So Thursday, that agenda packet will go out May 20th for the 24th. And the selected candidate would like to start work on the 25th.
Wow. All right.
Great.
Okay, that's great news. So do we have our EEO workforce statistics, Elizabeth?
Yeah, I'm going to wing it here a little.
Okay.
I've been on vacation. This is the first I've really looked at this, but so it looks like we only have 2 this week.
Mhm.
One of them is a very small business, Renovart with just two employees. And I know you usually treat those differently. In fact, they have, for 2 employees, they have quite a lot of diversity. The other is Corrective Asphalt Materials with 24 employees. And it's really not on the mark in terms of the comparison to the Champaign County workforce. I know last month you had a conversation about some of them that were not on the mark, maybe going with a 1-year approval to give them time to at least experience some turnover so that they could be able to show some improvement.
Yes, Pete.
Just a quick question. Is the Corrective Asphalt a renewal, or do you know, is this a new one or a renewal?
I do not know. Maybe Tamara would jump in if she knows.
I am pretty sure that it's a renewal. I will go back and look at their submission, but I'm pretty sure it's a renewal.
Because if it's a renewal, that means, assuming the numbers haven't changed significantly, I would presume we gave them the year before and asked them what was going on. And the COVID crisis and everything else that complicates hiring at this point. But I might be inclined unless we need some sort of just, they're waiting on the contract. I might be inclined to at least get some more information from them and wait until next month to find out what's happened in the year since, if it is a renewal. If it's a new one, then yeah, I think the year is perfectly appropriate.
I'm looking in the file now. It looks like they received a letter in May of 2019 that gave them a 2-year certificate. So
yes,
We
I
have
think
fewer
you're right.
than-
I found their submission email, and it's definitely a renewal, but I don't have those details Elizabeth was talking about.
So they're a very small, it's a small place, but I don't know if it's near any cities where they may be able to get some diversity. But it's really small.
They're located in South Roxana, Illinois.
Yeah. It's like maybe It's real small, like 2,000 people or something. So maybe that's why we did the 2 years, because they're so tiny that, you know, depending on where they're situated down there, they may not have access to diverse candidates. I don't know, diverse applicants. So I'm just throwing that out there. They're really tiny.
And they've, you know, they've got one minority listed, and that person has not turned over. So they actually filed the workforce turnover since the last time they got approved. That one minority employee has not left, and they haven't hired anybody new, but they have separated 10 people and hired 11 in that period of time with no change to minority. What is, you think I know this after all these years, what is our usual cutoff?
15.
15.
Maybe it was smaller then.
So I'd like to make a motion. I move that we approve, is it Renovart Innovations for 2 years, and approve Corrective Asphalt Materials for 1 year with the letter, and get more information about.
I don't know if it makes a difference, but South Roxana is in St. Louis. It's right by Southern Illinois University in St. Louis area. It's very close. It's a small town itself, but it is right there.
That does make a difference.
Yeah.
Yeah.
Yeah, that's very helpful, because that means they do have access to a diverse pool of applicants.
Yeah.
That's
So-
what we needed to know. Thanks, Megan.
Yes.
Yeah, so I
Good Googling.
I would like to find out a little bit more information, because when I pull it up, the borders, it's right by Southern Illinois University and right outside of St. Louis. So that's a little bit confusing to me. I think they would have a pretty decent access to a good, diverse group of applicants.
So your preference is not to give them the 1 year at this point, but go straight to ask them to provide information on their hiring practices?
I think I would like to, just by looking at where it's located. I mean, someone should probably double check me to make sure I'm not reading the whole situation wrong, but that's kind of where I'm leaning to.
Well, let me then withdraw my motion, and since I hadn't heard a second yet, and make a motion to approve Innovart for 2 years. Or
I'll second that.
Renovart. Okay, so it's been made and seconded. Any more discussion? Then we'll have a roll call vote on that motion to approve Renovart for 2 years. Tamara?
Sorry about that.
That's okay.
Stacy Burnett,
Yes.
Reverend Florence Capo,
Yes.
Megan McKissick,
Yes.
Peter Resnick,
Yes. Francis
Regberg.
Yes.
And you missed Carol because she joined the meeting after.
Yes, Carol. She gets a vote as well.
I'm so sorry, Carol Bradford.
Yes.
Okay, great. It passes. And when it comes to the other, we're going to get some more information from regarding the other company.
So, and I don't know, Elizabeth, have you done one of these before?
I have not.
Mhm.
And quite honestly, the next couple of weeks are going to be really busy with trying to push the final budget out. I'm actually on vacation until Monday.
Oh dear.
Oh, no.
But I will do what I can.
And this is basically, and Tamara might already have the text of the letter that we're talking about, but it's basically, we see we're renewing you. We see that you haven't done much hiring of minority candidates. Can you send us information about what efforts you're making to diversify your workforce? Because the commission wants some more information before we approve the contract.
I'm sure we can dig up whatever standard letters out there and send it. My only concern here is because I haven't been here, I have not been approving purchase orders. So I don't know if there's something pending, like if we have Public Works waiting to proceed on a project. I'm going to try and see if I can look at that real quickly.
And if that's the case, we can always do a special meeting or, you know, do some sort of temporary thing. But yeah.
I must say, when I think about an asphalt company, these are unskilled jobs. It just seems like there are, you know, whether it's in the Latinx community or the Black community, and if it's near St. Louis, there really isn't. Yeah, I think pushing back. Thank you, Megan, for.
Yeah. Because I did actually Google map it. It's 25 miles from St. Louis and 7 miles from Edwardsville.
Okay, thank you.
Judge
Okay.
Rehnquist on the Supreme Court used to bring an atlas to all the cases so he could tell where things were. I think that's a good habit, Megan. That's good.
Thank you, Elizabeth. Do you have anything to add for your report? I mean,
I would say, Tamara let me know that there was one call while I've been out about a discrimination complaint. And while I've been out, another employee has been taking those calls, and I understand they've been playing phone tag, so I don't have any additional information at this point. But as you know, where appropriate, we've generally been either referring those to the Illinois Department of Human Rights or to HUD. But soon we'll actually have an HR EO who will be able to handle those things. So.
yeah, that's great. That's great. Thank you. Any other announcements? Does anyone have an announcement they'd like to make? I'd like to thank Esther again for a great presentation. And I think that concludes our business. So the meeting is adjourned.